Hi, everyone. Welcome to the Immigration Lawyers Podcast, episode number 225. We're doing a federal litigation update with our wonderful colleague, Kevin A. Gregg. And there's two Kevin Gregg, so it's important to know it's Kevin A. Gregg that
Yeah.
working with a fabulous attorney with the podcast Immigration Review, which is like a godsend. We talked about the toolbox and all that. That is a primary tool in your litigation toolbox or, BIA appeal, that kind of stuff. Definitely check it out. I want to thank you for always coming on every month. I want to remind everybody that the Immigration Lawyers Toolbox magazine issue 3 is out. Previous issues are there as well. Treasure trove of information. Check it out by going to immigrationlawyerstoolbox.com/magazine and support your firm by reading it and learning the stuff there. But also support our sponsors, in particular DocuWise, the all-in-one form system and office management system that's just growing and new versions of it coming. It's just awesome. If you want to get extra 10% off, just go to DocuWise.com/immigration-lawyers-podcast. Use the code Immigration Lawyers Podcast. And also, if you're interested in learning about marriage immigration, you're trying to switch practices over and you're listening to this podcast because you're learning it. So many of my listeners are people who are trying to make the transition. We have a course on this stuff that breaks down adjustment of status and admissibility, consular processing, all in one. That's tens of hours of additional information and office hours. That's really going to get you ready for it. Just email me at info@immigrationlawyerstoolbox.com for information about that. And what was the other thing I had to plug? So there's just so much stuff, but definitely check out the magazine. We have all these different services. You're trying to be an immigration attorney in general, just email me. We'll have a quick chat. I love talking with colleagues. So with that, let's bring in Kevin. How are you doing?
I'm doing good, John. How are you doing?
Doing good. Kevin, the man who's going to have a really wild January traveling the country. Do you get a chance to see the country? Is it airport to court, back to airport, which that's how it is when I go to field offices?
Yeah, I mean, it depends. And actually, I'm going to San Francisco for a USCIS interview, and I could have done the weekend, but I decided not to with all the other travel and with COVID. But I will be staying near the water, so that's good enough for me.
Interesting.
And when I get to go back to South Florida, I get to see my parents, so that's always a good time too. But tomorrow I go to Dallas. I'm pretty excited. I'm gonna have a removal case. It's an interesting case. Can't talk about it on the show, but I'll let you know next month if we succeeded, and if so, we'll talk about it again.
Real cool, real cool. So you have to heavy schedule, and that's the cool thing about immigration practice, the federal practice, and you go all over the place and really see the country. And you can plan it out. I've had it where I had cases in Las Vegas or Seattle or something. We planned the vacation around it. It was easier to do before. Now it's with kids and COVID, it's just too much hard. A lot of times, I want to go and come back as soon as possible because it's hard to be away from the family. But it's a lot of fun to be able to do that travel at least.
Yeah, it's good. And I like it at this time in my life. I don't know. Talk to me again in 10 years, but I like it right now.
I hear you. So what's going on in federal litigation? How many cases do we got to talk about today?
Oh, I got 4 up here. December wasn't so busy, although there was some at the early part of the month, it seems. I mean, I've just become this weird circuit watcher, right? And I kind of can tell when the circuits are going to die down. They kind of cool down a bit at the Thanksgiving to December, but then they pop up again. I don't know. Nothing big this week yet, although the Fifth Circuit just issued something. If anyone in the Fifth is listening who publishes, they are the most annoying circuit for me because they'll publish decisions at like 5 p.m. Pacific time. So like I think maybe on a Friday I'm done, and then boom, Fifth Circuit decision. So if anyone's listening at the Fifth Circuit's clerk's office, maybe figure out something else. But no, I've got almost all Ninth Circuit this month for talking about the December cases, because interesting things are happening in the Ninth Circuit, and there are just some great quotes, and I love great quotes. It's what I do on the podcast, and thank you for the kind words about it. But sometimes I issue my thoughts at the end of some cases, but at the end of the day, it doesn't really matter what I think, and so I try to use quotes as much as possible. So when a circuit is using good quotes, I gravitate towards it pretty heavily. But the first decision I want to talk about is the First Circuit from last week, Brito v. Garland, which is the appeal of the district court action in Brito v. Barr, which is about detention and bond procedures. And it was a pretty complicated decision. At the end of the day, the First Circuit held that the plaintiffs, ACLU and a bunch of other entities, didn't have standing, and the court didn't have jurisdiction to get a nationwide injunction against ICE and the immigration courts to conduct bond hearings in the way that the district court judge ordered that they do. But at the same time, it seems to me that the First Circuit held that, yes, indeed, the U.S. Constitution mandates that for a regular, non-criminal, non-mandatory detention non-citizen, the government has the burden to.
Wonderful.
Yeah, the government has the burden to show by a preponderance of the evidence. Well, let me get the actual quote right. Well, clear and convincing evidence that the non-citizen is a danger, or a preponderance of evidence that they're a flight risk. And of course, if you're a flight risk, that's not to say bond is necessarily denied. There's often a number where just because you're a flight risk, it can be granted. And so the government has the burden, it seems to me, in the First Circuit, notwithstanding the fact that the injunction has been vacated, because, and I'd be interested to hear what other people have to say about this, but if the First Circuit is saying it's unconstitutional to hold a non-citizen who doesn't have a criminal history or who's not mandatory detention without placing the burden on the government, you don't need an injunction for the immigration courts and for ICE to have to follow that. That's the First Circuit in the First Circuit saying what the Constitution requires.
Yeah.
As I said on the podcast, and this is completely me reading the tea leaves, I mean, I'm sure the First Circuit believed its decision, but I'm also pretty confident that the First Circuit knows that in Garland v. Gonzalez at the Supreme Court this term, the Supreme Court might be poised to substantially limit, if not eliminate, district court judges' ability to grant nationwide injunctions in the immigration context.
Yeah.
And so if they had upheld the district court's decision on the injunction, the entire thing maybe goes out the window in a couple of months at the Supreme Court. But if you just do it on constitutional principles, it stays. And so I'm not inferring that the First Circuit was playing politics, but that issue is out there, and that does seem to be what's going to happen on Garland v. Gonzalez, because the court requested briefing on that issue, even though it wasn't at issue below in Garland v. Gonzalez. So, someone at the Supreme Court wants to write a majority or a dissenting opinion limiting district court ability to grant nationwide injunctions after everything that was happening during the Trump years. Mm-hmm. Anyway, point is, in the First Circuit, immigration practitioners appear to have a very favorable bond framework.
Nice. Well, very good.
So
and we'll see.
Burdens are important, and there's no statute, there's no reg that I know, at least on reg, but there's no statute that says the non-citizen bears the burden on bond, and that's not the case in the criminal system. I don't believe. I believe it is stemming maybe from a board decision from a long time ago, but why? And so, if the U.S. government's going to detain someone, it does seem proper that the government should justify its detention.
Yeah, I mean, that just goes back to the founding. It's just, you can't be detaining people. Immigration status shouldn't matter. It just can't be detaining people willy-nilly like that. Well, that's good news, and the ninth will probably fall, so we just need some cases to push that, but it's good news that we're at the beachhead there.
Yeah, with the ninth, with the Rodriguez class action that's been before the Supreme Court at least once, maybe twice. I imagine it'll go before the Supreme Court within the next couple of years on whether the Constitution, I guess it is that exact issue, right? Whether the Constitution mandates a bond hearing with the burden shifted. So, I guess the First Circuit has spoken. Maybe Brito will go to the Supreme Court. Maybe the Biden administration won't appeal it.
I don't know. It seems like they're picking up where Trump left off. So they're arguing a lot of these cases where you're surprised when it comes to diversity, visa lottery, MPP, and all that kind of stuff. They're kind of following the same footsteps.
I give them a little, I give them some leeway on MPP. I mean, the Fifth Circuit has issued some very strong decisions, and the Biden administration has to comply with the Fifth Circuit. I don't know so much about it, but I do know that but for the Fifth Circuit's decisions, MPP would be gone.
Yeah, and I'm not too much of a specialist on that. I just heard they're still arguing and stuff like that. It's a complicated situation to the board. I don't know what in the world we're going to do about that situation, but they put the vice president in charge, and she's like, "Why'd you do that?" She's kind of like, "That's the last thing you want to." I'm presidential hopeful. I'm a presidential hopeful. Don't put this on me.
Right. Well, good. Good on Vice President Harris. Hope if she can solve it, she certainly has a pathway to the presidency.
Yeah, but it's one of those issues. It's like that's just gonna sink you. I don't see a way out of it. She's gonna be really clever, and so far, I haven't seen too much cleverness coming out of her office. We'll see about that. But what other cases are happening?
Yeah, so three other cases, and I'll go through it kind of quick, not to get so much into it, but Kumar v. Garland at the end of November, actually, November 30th, in the Ninth Circuit. Not so interesting. It's a pretty standard adverse credibility from India type thing. And it's interesting because it shows what the Alam v. Garland and Bonk decision from a couple months ago in the Ninth Circuit appears to be doing to adverse credibility, which also goes to USCIS credibility as well. And that is in Alam, the Ninth Circuit and Bonk held that all its prior holdings no longer good law in light of the Real ID Act, which came out a long time ago. All adverse credibility must be based on the totality of the circumstances. It can't just be like one thing and honing in on it without considering all the factors in totality. And so with Mr. Kumar, where the IJ relied on 3 or 4 inconsistencies and problems, and the Ninth Circuit only vacated like 2 of them. So there's 2 or 3. So there's at least one inconsistency that wasn't minor in Mr. Kumar's case. And usually that would have tanked his petition for review and it would have tanked his asylum case. But after Alam, the Ninth Circuit is saying, well, totality of the circumstances means everything. We've just vacated a couple of your reasons, so you got to do it again. You got to tell us whether under the totality, now that we vacated these other things, whether this adverse credibility finding stands. And that's a big deal. With a case like Kumar, in no way was a slam dunk adverse credibility challenge, which is really hard to do anyway.
Mm-hmm.
And so with appeals to the BIA and to the Ninth Circuit, I mean, Alam v. Garland does seem to be a groundbreaker for adverse credibility challenges because totality means everything. And if you chip away at one thing, maybe it all needs to be done over again, because how can you do the totality when the lower court relied on something that is now deemed to be insufficient?
For a case like this, or a person's in removal, and this is just practice and money kind of stuff, like how do people pull off challenging and moving this up all the way to the circuit and then have to go back? Are these usually, because you guys deal with these wealthier clients, do they just get the money together? Is it pro bono? How do you see people be able to financially afford this?
No, that's a big problem. I don't have an answer. It's a big problem. It costs a lot of money to keep doing this. Some of these entities that do these cases are nonprofit, or they charge a flat fee to go to the petition for review stage. They maybe charge less than us, but no, it's a big problem. Don't get me wrong. Sometimes we do pro bono. We've done a lot of pro bono in the last couple of years as well, but that is an issue. You can litigate the client to just giving up because they just don't want to fight anymore.
Yeah, so when I hear these kind of cases, especially in the asylum context, people have like immigration issues and a lot of circus decisions. Like how did they force this up, keep pushing it up like that?
Yeah.
There's a lot of cases where you just file appeal just to do it, and you bring nominal kind of paperwork and just pay the filing fee or something like that. But it's a big burden for people to challenge it. And so when you see it work, you're like, well, every case potentially could be argued. It really just comes down to you have the finances to be able to hear it out.
It's like very expensive to do. It's very hard to do petitions for reviews and make federal court argument. It's big leagues. That's an issue, absolutely. And how many valid, legitimate cases haven't made their way up to the circuits because people just can't afford it.
And it's the same with criminal context. When people are in jail for stuff they didn't do, they can't get a DNA test or this and that. Kind of knocking the vice president's office in California, she tried to avoid people who had DNA tests that helped them out. She would challenge that as top prosecutor in the state. But this is a major issue for the innocent. We got to the whole system was made to protect the innocent on the Constitution, all that kind of stuff. But yeah, it's good that at least some of them are going through, because the totality circumstance situation is a hard one because it's so subjective, and even it goes back, the judge could, it's hard to argue with something that's so subjective, but at least there's some better, standards there that give people a fair shot.
And it's better than the case law in all the other circuits, where essentially one inconsistency will tank a case, even if the IJ relied on many.
Like I've had colleagues have asylum cases where just like half a sentence of something was off, just people were saying it in passing, and I was like, oh, you got one thing wrong, the whole thing is bad. Where it's like not realistic, for you to remember a million different things and know by the book the way they wanted some officers. So yeah, it's it really has to push the totality of circumstances. You got to be reasonable.
Yeah.
I remember what I have for breakfast. Like it's it's hard to remember all these facts necessarily. So yeah, it's just a weird situation.
I was in a USAS interview recently where they asked the guy who's about my age whether he knew his non-citizen wife's what was his non-citizen wife's phone number. I'm like, I don't know my wife's phone number. It's I type in her name and the cell phone. That's an antiquated question. Like, who knows phone numbers?
They stopped. I used to force my clients to memorize it, but it's been a couple years, but they stopped asking because I think I used to. But
They asked it in LA.
In LA, really?
Yeah. Yeah.
I used to make it mandatory, memorize the phone numbers, but in the emails too. But I stopped because I hadn't heard it being asked in a while. But that's interesting that they ask again. Yeah, it's not a reasonable question. Nobody knows. I only remember phone numbers from before we had cell phones. My mom's number and my sister's number. I learned my wife's number because we used to go to the gym together and have to sign off emergency releases, and so I have to memorize that. But other than that, it's just no way I can memorize the phone numbers.
It's nuts. Under your question, how do these things make it to the petition for review stage? The next case, Nsimba v. Attorney General of the U.S. out of the Third Circuit, is such a case. It looks like on petition for review, Mr. Nsimba was represented by Dwayne Morris, which is a big firm. So sometimes that's how, they get there. And this is just a mic drop of a case for Congo asylum cases. And give it a read. Anyone who's got a Congolese asylum case, they got to read it. I mean, the quote, it is beyond dispute that the Democratic Republic of Congo has a history, pattern, and practice of persecuting political objectors, end quote. And it's a huge quote. Yeah. And it's full of it. It's great on reasonable relocation, IJ's cherry picking the record, how physical harm isn't required. All these things, really many of the points that DHS usually argues and that IJs often rely upon to deny. Third Circuit's going through it meticulously, saying why that is ridiculous.
Harm too. I've had friends say like they push him. It's like the threat of harm is enough. It's like what is? Isn't that the case where you don't have to have necessarily physical harm?
It is threat of harm, and so that's always been the case for the future persecution. But if you establish past persecution, then the government has the burden to, and the burdens flip, and so you always want to be in past persecution territory. And there are some circuits. And including the third, very expressly here and before, that says even past persecution doesn't require physical harm under the right circumstances.
Yeah.
I mean, the 11th Circuit has said that not being able to practice one's own religion is a form of persecution. That's not physical.
Yeah.
So this case is fantastic for a number of reasons. I highly recommend everybody listen to it or listen to the podcast episode where I try to quote as many things as possible that can be used in asylum cases.
Very interesting.
And then the last case that I want to talk about is the 9th Circuit. It's Walcott v. Garland. It was published on December 22nd. And this one is just absurdly complicated. I'm not going to get into it, but it's essentially about drug trafficking and whether it's a crime involving moral turpitude. And the case goes all through the 9th Circuit's prior precedent, and the 9th Circuit is distinguishing its precedent. And it is kind of fact-specific based on the Arizona statute at issue. But at the end of the day, it did hold that this specific Arizona transport statute of less than 2 pounds of marijuana is not a CIMT, in part because less than 2 pounds has been deemed to mean as little as 3 joints. And so, it's a wide range, and you don't know if it's the 3 joints or the 2 pounds, and so it can't be turpitudinous. It's a complicated analysis, as it always is. But
our audio video got cut off. So you're talking about drug trafficking. I remember number 2 in there. It's about 10 seconds back.
What was number 2? I'm sorry.
You said something. It cut off. So try to, if you have the frame of mind, go backwards 10 seconds.
Sure, no, it's about drug trafficking, and it's very complicated. It's about a specific Arizona statute, right? And it held that this specific Arizona statute is not a CIMT because it's transporting of 2 pounds or less of marijuana, and the way Arizona prosecutes it, it could be 2 or 3 joints, all the way up to 2 pounds. And so under the categorical approach, you don't know whether it's 2 pounds or 2 joints. And so that was one of the reasons it was held not to be a CIMT. And very fact specific, and it's a primer on making these categorical approach arguments. But what I like,
it's really important right there, because I thought like it's up to the petitioner or the applicant to be able to prove that. I didn't realize they could argue that. So that's going to be used widely in these kind of
It
cases.
depends, it depends. It's the realistic probability test, and it depends how it's being applied in all the circuits. And this is a whole podcast episode for another day, and I think it needs to go back to the Supreme Court. But even if we're talking about the realistic probability test, the applicant did prove it here. You don't have to prove it with your own case. It's with your own case or other cases. And here, Mr. Walcott, or Miss Walcott, I believe, found Arizona cases where it prosecutes 2 or 3 joints. And so that is sufficient to meet the realistic probability test. But very complicated issue. I believe that if the statute clearly is overbroad, that the realistic probability test has no role to play. And the Supreme Court in Duenas Alvarez, that is what they said there. But this is a whole nother conversation. But while I like Walcott so much, is because at the end of it, the Ninth Circuit says, just to paraphrase, essentially, societal attitudes towards marijuana are changing. And so because of that, the CIMT definition is changing. And in part because of that, transporting less than 2 pounds of marijuana is not a CIMT. And again, it's specific because it could have criminalized 2 or 3 joints. But the greater point is good. And the court talks about Lawrence v. Texas and how sodomy used to be a CIMT. And then, when case law changes, so too does the law, and the Ninth Circuit is poised to change the CIMT definition vis-a-vis marijuana because society is changing about marijuana.
That's a big deal. The case statements are a big deal. Wow.
Yeah. So those are the 4 cases, the 4 case rundown in 20 minutes.
We did an excellent job. Kept my attention going through all of them. Perfectly prepared. Sometimes it's like, this is getting too complicated for me. So I'll just say it for our viewers who need to know this stuff, but it's just beyond me. But all of them were really interesting. Thank you so much for coming on. It's January right now. These were the December recaps. We'll see you in a couple of weeks. You'll be having a busy month right now, so I don't know how you're going to get your podcasts out. It's been over a year you've had your podcast, right? It's been a year.
May 2020. It's been over a year and a half.
Wonderful.
It's crazy. Next week will be episode 89, and that's not counting the 10 or so special episodes of interviews. That's wild. It's a labor of love, as you know better than me, on episode 280 something or other.
225. We'll get to 280.
225. I'm sorry. 225.
Now, what have you? It's a new year. What has you gotten out of the podcast? Obviously, it's personal stuff, but have any interesting things happened or connections or things from 2021 in the podcast?
Oh my God, all the time. People reach out all the time, and I provide these self-certification CLE certificates. Mm-hmm. So people reach out for that, but people also reach out just to talk. When the Rodriguez v. Garland Fifth Circuit motion to reopen in absentia deficient NTA issue was percolating, and it's still percolating, I got like an immediate email from a listener talking about this is happening right now in a Texas immigration court, and this is how it's being applied. So I could convey that. No, I love it for how it enables me to talk to the greater community. I've been invited to speak at immigration events, and I really appreciate that, and I have a lot of fun. And my outline alone is 900 pages with all the cases. I'm working on a Fifth Circuit one right now, and so just for me personally, it's a giant case law brief bank for control find. I can be, wasn't there? I can be like Ira, but Ira says, look in my book. I believe there was a case, which is just the worst thing that Ira Kurzbank can say. But I'm like, wasn't there a case about marijuana in Arizona? I could swear, and then I can find it, in 30 seconds. And so
a lot of work to be able to prep that. I've tried doing that kind of stuff, and I have a library I've created for the toolbox, which I'm going to open up free once I clean it up a little bit. But I've just done videos where I have it because I'm like, that's the best way I could do is do title searches on videos in a library, but it's a lot of work. Have you ever been contacted from anyone from the government? You don't have to go too much into it, but any government officers contacting you?
Look, I've pushed it to ICE trial attorneys. I'm aware that people at various ICE offices, USCIS, and at OIL are aware of the podcast. I don't know how many, but I know that they do. And I know that immigration judges, some are aware of it. I don't know how much they listen, but so I with that in mind, but even if it wasn't, I tried to be fair, it is, I say it's not biased, and it's not biased legally, but of course it's there to try and provide a service for Immigration Respondents Council. and to
Mhm.
push the envelope rather than to contract the envelope. Because
Yeah,
what is the fun of being private bar if you can't push the legal envelope?
that's it. So you have in one podcast today the number 1 and 2 immigration lawyer podcasts out on there on the
Oh.
web. Check out Immigration Review and Immigration Toolbox and podcast. Check out the magazine. We're gonna have Kevin or someone from his firm give an article for the next issue. I'll put it on you. Just let
All
me
you
know.
gotta do is ask. All you gotta do is ask with enough time.
Well, okay, we have 2 months to start getting new articles for issue number 5. Number 4 is gonna come out any day now, I swear. But it's chock full of stuff. Check out the other issues and check out Immigration Review, the magazine for Immigration Toolbox, all that kind of stuff. We're here to serve. All right, guys. We'll connect with y'all soon. Thanks
Thanks,
again.
John.
Bye bye.